for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
There's a big fight between GoDaddy
Okay.
and the Motion Picture Academy. They had a big issue with the domain company GoDaddy.com. GoDaddy apparently cyber squatted on a bunch of domains that the Motion Picture Academy said belonged to them, because GoDaddy would then profit when people click on those domains instead of the Motion Picture Academy getting all the money from those Google clicks. The Academy claimed GoDaddy had acted in bad faith with intent to traffic the trademarks like Academy Awards and Oscars. And so I ask you, Mr. Cunin, you get to go first this time. Case or no case?
I am going to say that this is a case. You know, the first time I ever heard about this happening was shortly after this whole, back when this .com stuff started, back in my day, we didn't have the internet. There was only one source in town for information. It was called Grandma. But, yeah, when this whole thing started, I remember...
It's getting late. It's the third hour. That's the problem.
I remember Dan Marino, NFL quarterback. He wanted a danmarino.com, and he couldn't because somebody went out and had registered the danmarino.com name, and they wanted, and they said, well, you know, Dan, we'll sell it to you for $10,000.
Exactly.
And I know that when you go on to GoDaddy's website to try to register a domain name, sometimes you can get a domain name for $5. It's great. But if you go on with one that they think is a hot button domain name, they're going to charge you like $10,000, $15,000 for it.
ToddCunin.com as just an example.
Wow,
Well,
that's a big time name.
Apparently that name, GoDaddy will actually pay you to take it off their hands. I don't. So I don't doubt for a minute that GoDaddy has not gone out, and if it wasn't them, it's somebody else, has gone out and registered these names thinking that would be commonly used by organizations, not just with the Oscars, but with anybody that is a big organization to try to get them to be able to charge more for those domain names. So I'm going to say it is a case. And do we know when this was filed?
Let me look and see really quickly. I'm sorry. I was looking at something else. Let's go here. Case, was it filed? What was it filed? I do not know.
Okay.
I'm sorry.
And the only reason why I say that is because it sticks out in my mind that there was a recent law passed in California to go against this practice of cyber squatting, to prohibit it. I can't say that for certain, but if that is true and there is a law like that, then the Motion Picture Academy of Arts and Sciences may have an argument there if the name is tied to their trademark. And so GoDaddy would not be able to cyber squat on a name that's tied to a trademark. I say that the plaintiff, Motion Picture Academy, Hollywood, whatever, GoDaddy loses on that.
All right, that's fair enough. Mr. Penney, what say you after
Can you go in any more circles to get to your point?
I don't know. I was honestly, Fred.
Go some more circles before you get to the point.
I felt your pain. I was trying to help you out. And just
Did I tell you that I knew a friend? He's an old guy, and unfortunately he passed away before we go to the break. And I'm going to tell you what I think after the break. That in the beginning of the .com thing, he drove to San Francisco. He told me the story, and he bought lawyer.com for a few bucks. But that was when you drove to San Francisco, you walked into this office, and you paid for the domain. And he thought he was so smart, he sold it for $100,000 a few years later.
Well, I'd say that was pretty smart.
No, it's probably worth millions, billions right now. Who knows? But the point is, he got there right at the beginning. Dude, you should have bought lawyer.com, cars.com, attorney.com, whatever you want.
Radio.com.
For a buck, radio.com, you would have been independently wealthy. We're going to come back. I'm going to tell you what I think about this case or no case.
This is Radio Law Talk.
All right, we're back to the case or no case. What say ye about the GoDaddy, just parking a bunch of really cool names and who was it? The Motion Picture Academy?
Yeah, MPAA, the Oscars. Allegedly, they parked on things like Academy Awards, the Oscars, stuff like that, but related ones.
And I say the same as Todd. By the way, I didn't say my opinion is I agree with Todd. It's I think GoDaddy gets hit with that, and it's a case, and GoDaddy loses.
Well, that's interesting that
Oh,
both of you would
gosh.
say it was the case and that the Academy
No,
loses.
give us
That is
points.
really, really interesting. But for both of you who say it was a case, that would be Fred and Todd.
Oh, yes.
Booyah!
Scared
Got
you for
it.
a minute.
Got it.
However,
Oh, no.
but wait, there's more.
And now the rest of the story,
Right, exactly. The rest of the story. The
which we'll
Academy,
probably get sued for
I was just gonna
trademarks.
say.
Yeah, great.
Well, let's see what's back up. Now for another story.
Another story.
the Academy had hoped to win as much as $30 million from GoDaddy and looked to be the heavy favorite, giving
Yes.
earlier rulings in the case.
Ooh.
But then they went before U.S. District Court Judge Andy Barote Jr., and he decides there's a lack of proof of the Academy's claim. The lawsuit, Todd, filed in 2010,
Okay.
targeted GoDaddy for allowing customers to buy domains like 2011 Oscars, Beta Academy Awards, park those pages, collect a portion of revenue from the advertising partners on the click per pay. The judge concluded that the unique circumstances compel a finding that GoDaddy did not possess the requisite bad faith intent to profit from the AMPA marks. In addition, Judge Barote also speaks out about the nominative fair use of trademarks, speaking out about how newspapers are always airing ads that say Academy Award nominee,
It's a
Academy
general
Award
term.
winner.
General
Right.
term.
Yeah, they're using it, right. The judge said there is a fundamental problem with the Academy's theory of liability under the Anti-Cyber-Squatting Consumer Protection Act. And that, ladies and gentlemen, is
Yes. We got 1 point.
case or no case. And each of you got a point, so that's 2 points each for
Well,
you
there we
today.
go. Catching up with Denise, who's not here. That's
Yes,
just.
that's not good. Yeah, I was going to do double points on that, but I thought, no, that's not fair. It was too easy. So,
I'm curious. You said that was 2010?
2010, that's correct. Yeah.
Okay, because I'm wondering if I would have to. Yeah, it doesn't matter. I was wondering if the Anti-Cyber Squatting Consumer Protection Act has been amended since then to give specific protection if you can show I have a registered trademark for this.
Yeah,
which
I believe it may have been changed based. I mean, I'm sure after this there was all kinds of lobbying and knocking on people's doors saying, "Hey, how's that fair? You know, here's Kleenex. I own Kleenex. This guy puts Kleenex.com. Wait a minute, hold the phone, right?"
Yeah.
So I'm sure it's been amended because this is a very rapidly moving area of the law, and many times the changes, as Todd pointed out, in the law are moved by litigation.
And as part of that litigation, one of the things that would come up is, was the trademark appropriately given, or did somebody get a trademark for something that is too general, which prior to cyber squatting was always an issue? And
Go to the website, radiolawtalk.com. That's radiolawtalk.com.